Okay, we will go on the record then. The time is 6 p.m. This is a remand hearing for Deschutes County file number 247-230-000-599A. My name is Tommy Brooks and I am the hearings officer in this matter. Before we turn to the substance of tonight's hearing, I'll turn things over to Ms. House to describe how the hearing process will work.
All right, good evening. For the record, my name is Caroline House and I'm a senior planner with the Deschutes County Planning Division. Tonight's hearing is a remand hearing for an application to address issues remanded by the Land Use Board of Appeals as part of LUBA case number 2022-022. So I'll begin the hearing by going over the hearing format and how to testify. I'll have a brief staff report and then we'll begin the testimony portion of the hearing. The applicant will testify first, then persons in support. If there is anyone attending, I don't believe so, besides the applicant, and then anyone in opposition or the appellant in the proceedings before this. After that, the applicant will have an opportunity for rebuttal, and then if there are any closing remarks from staff, that will happen at the end. If you're testifying in person, so tonight's a hybrid hearing format, so both in-person and remote participation is allowed. Before starting your testimony, please provide your first and last name and your mailing address. There will be time limits on testimony, so the applicant will get 30 minutes, the appellant or appellants will get 20 minutes, and other parties will have 3 minutes, and then the applicant will have 10 minutes for rebuttal. If you're in person and testifying, hearings officer Brooks will call you up to one of the microphones here. And if you can make sure to speak clearly into the microphone, that will ensure the hearings officer can hear you and anyone else listening remotely. If you're attending remotely to testify, you must be logged in using Zoom. And hearings officer Brooks will request that all Zoom participants use the raise hand feature to notify him that you would like to testify. And to do that on a computer or a smart device, you'll need to press the raise hand button, which will be located at the bottom center portion of your screen. And if you've dialed in, you'll need to dial *9 on your keypad to activate the same feature. Written testimony can also be submitted to staff. If you're in person, please hand that to me. And if you're attending remotely, you'll need to email me that. My email is caroline.house@deschutes.org. The hearings officer and staff are responsible for an orderly and respectful hearing. If anyone's being disruptive, you may be asked to leave. And I'm going to pause now and ask if there are any objections to the hearing format that I just described. And if yes, in attending remotely, please use the raise hand feature. Are there any raised hands? So I'm going to ask if you have your hand raised, can you keep it raised if you have objections to the hearing format. If you have other questions, I'm going to ask for you to lower your hand until we get to a different portion of the hearing. Is their hand still raised? Okay, so there are no raised hands, so I'm going to go ahead and turn this over to hearings officer Brooks for his hearing instructions.
Hey, thank you, Ms. House. This application is a continuation of an earlier hearing and is still being considered through a quasi-judicial process. As a result, I will consider only the factual evidence that is in the record, and I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing, the remand hearing, were identified in the public notice that announced the hearing. Because the hearing is a remand proceeding, the scope is narrower than the scope of the initial hearing. As described in the notice, the single approval standard that needs to be addressed is DCC 1840-050 D1B(1). Within that approval standard, the specific issues that served as the basis for the remand was the lawful status of various parcels that are identified as Lot 2 and Lot 7, which includes Lots 7A and 7C. I have not received any request to open the record for the purpose of accepting new evidence. I am, however, opening the record to accept additional testimony regarding the evidence that is already in the record, so that the remand participants can present arguments on whether the approval standard is met. It is important that you direct all your testimony to the standard and to the existing evidence. If you believe a standard or a criterion applies that was not listed as part of the remand notice, you may address that unlisted criterion, but I urge you to explain in detail why the criterion must apply and to provide specificity so that others may respond and so that I can address that issue in my decision. If you are seeking to offer new evidence and not just argument, new evidence that addresses the applicable standard, I need you to first make a request to open the record for that purpose. I will address any such request if it arises, with the understanding that the county's code gives me discretion to open the record or to keep it closed for that purpose. The failure to raise an issue with enough detail that enables me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. And also the failure to raise a constitutional or other issue related to any proposed conditions of approval, again, with enough detail that allows me to respond to that in my decision, precludes an action for damages in circuit court. As I've noted, I serve as the county's hearings officer, and in that role, my job is to be an impartial decision maker. Thus, while I have a contract with the county to serve in this role, I'm obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record, I do not have any relationship with the applicant, and I'm not aware of any connections I may have to other participants in this proceeding that would prevent me from remaining impartial. I have briefly communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application or the issues on remand. I do not have any ex parte contacts to disclose. Before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter?
And I see no raised hands, so we're
okay. So with that, then I will turn it back to you, Ms. House, to deliver the staff report.
Yeah, and I did want to know, I probably should have said this at the outset, but I did receive a request from Wendy Kellington to open the record. I imagine she'll cover that during her presentation. I did forward that request to you, and it has been uploaded into the record, but that came in kind of late, just before the hearing. So
Okay.
just note that. And let me get to share screen. All right, so to start my staff report, just the location of the property is 59770 Scale House Road. This is just south of the city limits for Bend. And the request is for an application to address issues remanded by the Land Use Board of Appeals, as I stated earlier. And the remand is specific to a Deschutes County hearings officer's decision approving a conditional use permit to establish a template dwelling on the subject property. The issues on remand are all centered around whether the template test requirements are met, and specifically whether there are at least 7 lawfully created parcels within the template. So for my staff report today, I've gone through 4 of the issue areas on remand. I do want to acknowledge that the one of the parties has raised other issues that they believe is relevant for this particular hearing, but for the purposes of my staff report, I've just incorporated the 4 that I'm going to cover. So the first is the hearings officer's conclusion that Lot 2 was lawfully created was not supported by substantial evidence in the whole record. On remand, the county should determine whether Lot 2 was created in one of the ways specified in ORS 215-010 subsection 1A. Secondly, the county's findings must explain why Lot 7 is a lawfully created parcel and address the legal effect, if any, of the deeds from 1980 and 1982 that transfer property without complying with county partition regulations. Third is the hearings officer did not directly address petitioner's argument that the 1980 deed created Lot 7, so the findings are inadequate to address opponent's argument that Lot 7 is not a lawfully created parcel. And lastly, the hearings officer's findings are inadequate to explain his conclusion that Lots 7A and 7C are lawfully created parcels. On remand, the county should determine whether Lots 7A and 7C are lawfully created parcels under ORS 215-010 subsection 1A. So all of the record materials that have been received are published at the website that's displayed on the screen. There were a few late submittals, but those have been uploaded to the record. And that concludes everything I was going to cover, but I am available for any questions from the hearings officer at this time.
All right. Thank you, Ms. House. I have no questions for staff, so we can begin with the applicant.
So Ben, if you can elevate Deborah Kerr and Wendy Killington, please.
Yay. Thank you. I hope you can hear me. You're smiling, so I think you can.
I can. Thank you.
Awesome. When you were saying earlier that you wanted to know if people could hear and you were trying to hear, I was raising my hand, trying to say, I can hear you, but you can't hear me. But I guess that was the panelist thing not working out. So anyway, my name is Wendy Killington. I am an attorney at the Killington Law Group at 4500 Cruise Way, Suite 340, Lake Oswego, 97034. I represent the applicants, Deb and Hodge Kerr. Couple of housekeeping things. Number one, typo escaped in my request for remand at page 6. The reference to attachment 4 should be exhibit 6. Apologies for that. And then the other, less housekeeping, more substantive, is a request that a letter that I submitted earlier this afternoon be included in the record of this proceeding. It's in response to the letter that we received from Mr. Kobach this afternoon, in which he expressed the concern that lot 7C is not in the template. And I just asked our surveyor to write me a quick letter that says that in fact he's a certified smart guy and he did the survey and he was able to do it, and lot 7C is in the template. And so I would request that that letter be included in the record. Should I proceed or wait for you to decide?
I think go ahead and proceed. I saw a reference to that, but I don't know that if I actually have the letter. So I think I was thinking you had your initial letter, which had only evidence from that was already in the record. So it sounds like you have something new with, and it's, I guess I would ask you to characterize it as either additional evidence or additional argument.
It's additional evidence because it's a letter from the surveyor that responds to the issue that was raised this afternoon about lot 7C.
Okay.
So, yeah.
Let me go ahead and proceed. I'm inclined to include it. I want to make sure that I'm giving other participants, since if it's new evidence, you may need a chance to respond to that. So, but please proceed based on assuming that it's in the record.
So I'm wondering if you can see my PowerPoint.
I cannot.
Okay, so let me do the screen share thing. I am not a technophile, so a person has to be a little patient with me here. Here it is. Sure. Can you see that?
I can see that. Yes, thank you.
Okay. And so hopefully you've got a blue screen with the first page of what looks like a PowerPoint. Yes?
Yes.
Yay. Okay. And I note that the file numbers are incorrect. I think I grabbed the ones that are from the original hearing, so apologies for that. So I want to begin my presentation by just talking about some things that are not at issue, because I think that's really important. What is not at issue is that LUBA affirmed the template. LUBA decided that the template that was drawn meets all applicable standards. That's at page 16. And this is an image of it. And I found it was very helpful when I got into this case, which is otherwise a little mind-boggling and complicated. LUBA decided that, quote, the hearings officer concluded that interveners established that there exist 9 lawfully created parcels within the template. LUBA didn't disturb that finding. That was, again, a hearings officer finding that all of the parcels that were at issue are within the template. LUBA could not have found that the issue on remand is whether 7A and C were lawfully created unless they were inside the template. If they were outside, their legal status as lawful parcels would be irrelevant. So the issue about whether the parcels are in the template has been established. LUBA also affirmed that the relevant law requires just 7 lawful lots or parcels be established. LUBA affirmed that there are 5 lawful parcels. Lots 1, 3, 4, 5, and 7B are lawfully created parcels. And that means that the Kerr family needs to only show that there are only 2 other legal parcels in the template. And as staff eloquently described, LUBA's instructions on remand that are relevant to my presentation tonight are at page 29, in which LUBA said, on remand, the hearings officer should determine whether lots 7A and 7C are lawfully created parcels under 215.010. That is the law of the case. Lot 7C is a live issue because, again, it's in the template. A key holding of LUBA's is that lot 7B is a lawful independent parcel. And that is the 100-foot strip that was dedicated in fee to the railroad by the Fergusons. And you can see the as-built drawing here in red of the railroad in the relevant area. The 1910 deed, which is in the record at 1286 to 87, from Ferguson to the Oregon Trunk Railroad, created Lot B and the lots on either side of it, Lot 7A and 7C. This image is helpful. It's from the record at 1127 to see where exactly lots 7A, B, and C are on the template. You can see lot 7A is to the east. You can see lot 7B is the railroad strip, and you can see lot 7C is to the west of the railroad strip. In Lovinger versus Lane County, LUBA stated the following, and I quote, "The transfer to the county in 1959 created 3 separate parcels of land. The strip of land owned in fee by the county and the 2 parcels of land lying on either side of the roadway, the properties that are now identified as tax lots 200 and 203. In other words, the conveyance of a fee for a roadway to another party was in effect a partition of not only the subject property, but the lots on either side of it, or parcels on either side of it. That decision was affirmed by the Court of Appeals, and I quote, "We therefore conclude that LUBA did not err in determining that the deeding of the strip of land to the county in 1959 effectively partitioned what was then tax lot 200 into 2 separate parcels, and that, as a result, the county was not precluded from approving an application for the construction of a forest template dwelling on each of the 2 resulting tracts." So here we have the same situation. Again, the deed at record 1286 from Ferguson to the Oregon Trunk Railroad has been held by LUBA and affirmed by the Court of Appeals to be a fee conveyance to the railroad of a strip of land, lot 7B, from lot 7A and C, creating 3 parcels. LUBA's holding, LUBA's holding re lot 7B about its location being uncertain is a resolved issue under the law of the case in Beck versus Tillamook County. LUBA decided that the location of lot 7B was not uncertain, even though or so uncertain that it would preclude the conveyance of a fee for a person to know what they were acquiring. Petitioners raised that issue at LUBA and they lost it. So their issue about the location of Lot 7B being indeterminate was resolved against them. Their issue was that no fee interest could have been conveyed because the strip's location was indeterminate. They lost that issue, and that's clear as day if you compare the LUBA petition for review in the record at page 27 to 28 with LUBA's final opinion and order at page 28. LUBA decided there was adequate evidence that a reasonable person would rely upon to conclude that a fee interest had been transferred based upon the quote, specific description of the location of Lot 7B. LUBA at page 28 said that your findings are, quote, adequate to explain that the hearings officer relied on the express language of the 1910 deed, its binding effect on successors and assigns, and its specific description of the location of Lot 7B to conclude that it transferred a fee interest in the property. That issue is over and done with. Lot 7B was conveyed by a fee, and we know where it is, and created parcels 7A and C on either side of it. And again, regardless, LUBA would not have remanded for you to decide whether 7A and C are lawful parcels if they're outside of the template. There really can be no reasonable doubt that 7C is in. So as a precaution only, we will respond briefly to Mr. Kobach's assertions regarding the uncertainty that he alleges with regard to Lot 7B, which is again that railroad strip in the middle. The 1910 deed from Ferguson to the Oregon Trunk Railroad gives a location that was used by the applicant's surveyor to create the template that LUBA affirmed. That 1910 deed relies upon the center line of the parcel as it was staked out in preparation for the construction of the railroad. The deed did give some flexibility for adjustment to the center line during construction by referring to the center line of the parcel as, quote, now or may hereinafter be located and staked out. The deed had definite and fixed boundaries, though, once the railroad was built, because it also provides the right to take from the lands adjacent to and outside of the strip earth and stone to build the railroad. The railroad in turn was built in a specific location, and that location, Lot 7B, was then fixed. There's never been an admission that the Lot 7B boundary could not be determined. LUBA's remand specifically required the hearings officer to decide whether Lot 7A and C are lawfully created parcels, and that is the law of the case and is not subject to challenge now. Kerr's surveyor has also confirmed in the letter that I asked that you accept into the record that Lot 7C is within that template. He says he's a registered surveyor who prepared the template, that he was advised that LUBA determined his template was properly established. And he says he understands there's a question about whether Lot C is within that template. He gives his professional opinion that it is within the template, that he located the railroad parcel 7B shown on the template that LUBA reproduced in its opinion, that Lot 7C shown on the template was created when 7B was divided away by deed, and attests that Lot 7C is within the template shown on LUBA's final opinion and order at page 16. Moreover, there is nothing that undermines the lawfulness of lots 7A and C. And while I didn't see that opponents raise this issue this go round, they have before, and to anticipate it, I just want to point out that subsequent unlawful conveyances, deeds, do not disqualify a lawful parcel as it existed prior to an unlawful conveyance. from being counted to meet the requirements of the forest template test. That comes right out of the Castle Land Watch Lane County LUBA opinion. There's no dispute in this record, I don't believe at least, that any later conveyances by deed required partition approval per county standards that came into effect in the beginning in 1977. So therefore 1980s deeds that were previously presented didn't comply with county code requirements that were in effect at the time, and so could not have undermined the lawfulness of the otherwise lawfully created lots 7A and C. There's never been any partition approval that has been given that eliminates lots 7A or C or B for that matter. And I give you the dates in this PowerPoint of the two relevant county code provisions, January 5th, 1977, and then again, September 17th, 1980. So the conclusion that we hope that you will be able to find again is that LUBA has decided that the relevant law requires there be 7 legal parcels in the template, has decided that lots 1, 3, 4, 5, 7B are lawful parcels within the template. That leaves 2 more that must be determined. LUBA decided that lot 7B's location was determinable and as a result conveyed a fee interest to the Oregon Trunk Railroad. Whether lot 7B's boundary is determinate has been resolved against opponents. As a precaution only, we would ask the hearings officer to once again find that lot 7C is within the template, as is clear from the image of the template that LUBA affirmed in its final opinion and order. The undisturbed hearings officer finding that LUBA recited that all lots are in the template, and the credible written testimony of Kerr Surveyor. Lots 7A and C are lawful parcels created by the Ferguson 1910 deed to the Oregon Trunk Railroad under Lovinger. Under both LUBA's decision and the Court of Appeals, a deed transferring fee title for a road, or here a strip for a railroad, divides property. And as a matter of law, lots 7A and C are lawful parcels and are properly counted in the template. Therefore, there are 7 legal parcels within the template. And that's all I have for you. Thank you for your time and listening. I'm available for questions. And I know Deb Kerr has a few brief remarks to share.
All right. Before we get to Ms. Kerr, let me ask you a couple of questions, Ms. Kellington. I guess one is your initial submittal for the remand, I think does address the status of lot 2. You haven't really focused on that this evening. Is there any additional detail you would like me to have about the status of lot 2 or in terms of whether or not that's still an available lot to include in the template?
Thank you. That's a good question. I looked for additional information regarding lot 2 and didn't find it. And so my only answer with regard to lot 2 should have been, answered by the Ganson case, where the county has made a final legal lot determination with regard to lot 2 in 1313, which was a determination that is not just a lot of record determination that applies only standards regarding whether there have been building permits or that sort of thing. The first standard, as you know, in the county's code that was in effect at the time, requires a determination of whether the underlying lot was legal. And so my only answer to you on the lot 2 issue is that issue has been decided in a previous final land use decision, and at least under Ganson, which was a LUBA reversal of a later collateral attack on a final land use determination regarding the lawfulness of a lot. It should remain undisturbed, but I don't have anything else.
Okay. Thank you for that clarification. I guess the follow-up question that I have for you is, I understand your argument about lot 7C being a live issue, and how, thank you for pointing out the LUBA language that addressed that. I think where I'm in sort of the issue that's been raised by the appellant is still how that was couched in the original application, and that the applicant was not relying on 7C. I can read it a couple different ways, and so I would like to know the applicant's position on why, even if LUBA thinks it's a live issue, how that comports with what the applicant proposed initially.
So the applicant initially didn't think that they needed to deal with these railroad parcels. And as you know, they focused on other parcels. And LUBA felt differently, but they didn't say we are waiving any right to claim that lot 7C is a legal parcel. What they said is that they didn't have a lot of information and that they chose to focus on other things. LUBA really wasn't much moved by that, as you know, in footnote 9 of their opinion. They said, they recited in the application, the applicant said that they weren't relying on lot 7C, I'm sorry. But of course, in the briefing, the applicants relied upon it and made arguments about it, and the petitioners relied on it and made arguments about it. And LUBA resolved those issues and made a final decision that despite all of that, that they wanted a determination from the hearings officer with regard to whether lot 7C was a lawful parcel. And I think under Beck, that's the law of the case. And if Mr. Kobach was dissatisfied with that, and if he felt that lot 7C, had somehow, been taken off of the table, his obligation was to include that as an argument in his Court of Appeals case, but he did not. And so it's a final and settled issue that lot 7C is one of the lots that must be determined to be lawful, and if determined to be lawful, could be included in the template dwelling count.
All right, thank you for indulging that question. I don't have any other questions for you, Ms. Kellington. So Ms. Kerr, if you want to use the remainder of the applicant's time, this is your chance.
You hear me?
I can hear you. Thank you.
Okay, hi. So I'm supposed to give my name, address. Is that right?
Yes,
Or-
please.
Deborah Kerr, and I live 21345 Southwest Edie Road, Sherwood, Oregon 97140. Just want to thank you for your time. I'm one of the owners and applicants. And I just really wanted to add just kind of a recap of this whole lot. So as you may remember, our template dwelling was approved by the county before several years ago in a final land use decision, and due to personal circumstances, unfortunately, the permit slipped by us and we lost it. So we were devastated by that, but hope that this time around will lead to another positive outcome for our family. Our property and the property around it has long been associated with our family, actually for decades, and it's very special to us. We want very much to build our home to be next to Hodges' parents so that our kids can grow up on the family property within walking distance of their grandparents, and also have a legacy to leave behind, as it's part of the my husband's father started the Hydrogen Museum, which is right there on the property as well. And we want to preserve that. So I want you to know that we very much appreciate your time, attention, and courtesy to this matter. We also appreciate the county staff for all their hard work on this over the years. And we hope that when all is said and done, we can be friends with the neighbors. And I thank you again for your time.
Hey, thank you, Ms. Kerr.
Hey there, hearings officer Brooks, if I can make one last comment, would you mind?
Sure. I don't mind.
Okay, thank you. I don't think you need to get to this weed, but just in case the question you asked me, you've got a code provision 2240 or 2234-040. It's the same one where you can reopen the record. It also says that in your discretion on a remanded application, the land use permit application can be modified to address issues to the extent such modification would not substantially alter the proposal, would not have a significantly greater impact on surrounding properties. That would be another sort of a fallback basis that a person might consider when they respond to the 7C argument. I think it's several layers down. I really think the better response is that the one that I gave, 7C, is now a part of the remand ecosystem. Didn't like it, you have to appeal it. Otherwise, Beck says, it is what it is. But a fallback would be that 2234-40 if a person wanted to. So that's it. Thank you.
Thank you. All right, that concludes the applicant's presentation. Ms. House, I'm assuming no other participant has signed up in support.
No, there's not anyone else.
Okay, so we will move on to the appellant.
Good evening, Mr. Brooks and Ms. Kellington. I'm Chris Kovac, and my office is 78 Northwest Kearney, Bend, Oregon, 97703. And I'm here to represent the Windlinx family, or the Ranch Trust, as I did before and at LUBA. And I'd like to start with the procedural issue about the record being reopened, and we would oppose that. We didn't put any new evidence in our material. We cited in our letter the lack of evidence in the record to support some propositions, but it would be prejudicial to allow the applicant on the night of the hearing to reopen the record to put in evidence and not having any ability to respond to that evidence. If you read their submission, they were a little inconsistent on whether they were going to ask for it, but they came down saying we're not going to ask for it, but we may reevaluate that with respect to lot 2, nothing about lot 7. So if you were going to reopen the record to allow that letter in, I think you'd be substantially prejudicing the rights of the Windlinx Ranch Trust, which would not have had the ability to respond to it. And I know that, clearly was done quickly and has no detail whatsoever. It's a surveyor saying he's attesting that a piece of property is in a certain location. And I heard counsel refer to it as a survey. Well, this isn't a survey. A survey finds monuments in the ground or from prior surveys, and they tell you exactly where those monuments are and where the boundary lines of property are. This is nothing like that at all. It has no basis for why he concluded or attested that the location of the property is anywhere. If this were a survey and it was submitted to the county would laugh at it. You can't tell anything from this letter. He doesn't cite any evidence he relied upon. He doesn't cite a monument. He doesn't cite another survey. He doesn't cite anything. And what I would get to is, the standard is substantial evidence in the record. I know that's less than what the courts rely upon, but it's vastly different than the standard that was in some proceedings. And this is in that Armstrong case that's in our letter. Is there is or was another standard that allowed somebody to succeed with any evidence. Now, this is probably close to any evidence. It might not even be any evidence, but it certainly isn't substantial evidence. And so given the lack of quality, the lateness of it, and the prejudice that would fall on my client, we would request that you not reopen the record for submission of this and base your decision upon the current record. So moving on to the more substantive things, I don't think LUBA's decision goes as far as the applicant states. First of all, I think LUBA, the decision wasn't very clear. And in one respect, I think it really misstated your findings. So for example, counsel for the applicant refers to page 16 where LUBA said that you found that there were 9 lawfully created parcels in the template. That wasn't your finding. If you go to your finding on page, this is page 51 of the LUBA record, it's 17 of your decision. What you actually found was that the applicant, you found the existence of 9 lawfully created lots as presented, all or part of at least 7 other lots or parcels that existed within the template. So your finding was really a little more constrained than what LUBA said. And I don't think LUBA misstating your findings makes your findings different than what you actually wrote. What you wrote was there were at least 7 parcels in the template, and you didn't identify them. So there's no way from your finding that LUBA could have known whether you included as one of those 7 the railroad parcel or 7C. And then when LUBA went on in page, they noted in the footnote that the interveners were not relying on 7C. And they cite to that record. And when the applicant says, well, there's no admission, I just think you got to read that letter or that page. It's pretty clear that the applicant stated in their application, Lot C is an area located west of the railroad parcel. It is believed that a small part of Lot C lies within the template. The applicant is not, however, asking the city to count Lot C as a parcel that is located within the template because the exact location of the railroad parcel is not known. That's an admission. That's a concession of significance. Now, there's nothing that was cited to you where the applicant changed that position. I heard argument that the applicant somehow in briefing changed that position. There's nothing cited in the record of the local proceedings where the applicant said, well, no, we're going to modify our application because now we have proof that Lot 7C is in the template. They didn't present any additional evidence at the lower record that I'm aware of that the railroad parcel was somehow locatable within the template. And so when LUBA was talking about the lawful creation of Lot 7C, that's all LUBA was talking about. LUBA specifically said on page 28 that the hearings officer's decision does not address the evidence in the record petitioner cites that calls into the question whether the 1910 deed transferred fee title or an easement, and in particular does not address the evidence in the record that concedes that the location of 7B based on the 1910 deed is unknown. So LUBA is recognized in stating here that there was evidence in the record that the railroad parcel's location was not known. Then they went on to say that the findings, however, barely so, explain why you relied on the express language and its binding effect and its specific description to conclude that it transferred a fee interest. That's all LUBA found, is that your findings established were sufficient to establish that the transfer in the 1910 deed was a fee parcel. LUBA never said, we conclude that 7C is in the template. And that's inconsistent with their footnote on page 16, where they said the applicant's not even relying on it. So to say because LUBA found that because LUBA remanded to find whether 7C and 7B were lawful or 7A were lawful parcels, LUBA had to have concluded that they were within the template. I think that goes too far. If you put all of this in context, LUBA had no reason to talk about the location of 7C because the applicant wasn't even relying on it. And we did try to raise this. We tried to raise this throughout the proceedings, and unfortunately, LUBA just didn't decide this locational issue, and nor did the Court of Appeals. We think whether or not the 7B, the railroad parcel, or 7C is in the template is still undecided, unfortunately, and we don't believe the Beck case applies in this situation. So, getting to the core issue, are there 7 lots or parcels within that template? Well, first of all, let's look at lot 2. Lot 2 cannot be a lawfully created parcel. So, you know, the collateral estoppel argument just doesn't hold weight when you consider LUBA's decision in Grossman. So LUBA basically, and Grimstad. So LUBA in 2 decisions basically said to the county, listen, what you do on your lot of record stuff, that's okay. You can do what you got to do and you can verify these lots of record. But that doesn't mean those lots of record are also lawfully created parcels for purposes of state law. To the extent that your lot of record verifications overlap with 90 ORS 92.010, well, then maybe it's true. But you got to check both boxes. And so when the county verifies a lot of record based upon it being a remainder parcel, well, the state law doesn't have a comparable provision. And that's what LUBA held in Grossman. It doesn't count. And here, what LUBA or what the county did in 2013 was they took their lot of verifications process beyond recognition. So the lot of record verification, the definition is 5 components. And then through policy, the county added a 6th. And this was the case in Grimstad. In practice, the county would look at a lot, and even if it didn't meet one of the 5 verification definitions, if the county had issued development permits for a parcel, even though it hadn't been created in one of those 5 ways, they would verify it as a lot of record. And I don't know where that policy came from. Maybe they were embarrassed that they issued permits wrongfully, but that's what their policy was. And Grimstad, LUBA said, that's crazy. You can't do that. You can't create a lawful development permits do not create lawful parcels. That's not, you can't do that. And so on lot 2, it goes one step further. The staff person for the county that approved lot 2 verified it based upon development permits that were issued on a different parcel, the museum parcel next door. It was even worse than Grimstad. So lot 2 under LUBA's clear holding in Grossman cannot be a lot of record because the only thing that separated lot 2. So let me back up. In 1910, when the railroad deed was there, we're not quibbling with that. That LUBA ruled that was a fee parcel. Court of Appeals affirmed it. It's a fee parcel. No question about it. But in 1910, what that separated was not what is presented by the applicants as lot 7. It separated that 160-acre parcel of the Ferguson tract, however big it was, the big Ferguson tract. And that left a significant piece of property to the east, which consists of what is now identified as 7C and 2. So when the railroad parcel came up, it separated this big parcel, and you have this lot, this big chunk that is 7A and lot 2. And then the only subsequent act that purported to convey lot 2 as a separate parcel was that 1981 deed that I referenced in our written submission. It's the deed where the Brooks Resources conveyed to the McNaught Company, in which the Kerrs were partners, what is described as lot 2. Well, that was after 1977. So that deed did not legally separate lot 2 from its bigger component that the railroad that was there when the railroad went through. And so the consequence of that is that is one piece of property. Everything east of the property known as the railroad tract, lot 7B, all the way up to lot 1, that's still one parcel. And so that means when you take out lot 6, because that we won on lot 6, then if you can't show that both lot 7B, the railroad parcel, and lot 7C are in the template, if you can't reach that conclusion based on the evidence, then there's only 6. Because even with lot 7B in the template, there's only 6 if you get rid of lot 2. So 7C, the location of 7C is very, very critical. And if you look at the current record, there is no evidence that lot 7, there's no evidence that refutes the point blank admission by the applicant that they're not relying upon it because they cannot tell you where it's at. And if they cannot tell you where it's at, they cannot tell you it's in the template, because you have to know where it's at to say it's in the template. Now, If you look at the evidence in the record, the only thing the applicant relied upon were these two sections of the ODOT map, one in unit F, and I pointed this out. So in unit F, there's that railroad or the ODOT map. There is a notation to the Oregon Trunk Railroad on the map page for unit F. Well, you can see from those maps, unit F is down where the little Deschutes meets the big Deschutes. That's noted on the map too. And so if you rely on that evidence, you can see that that's about 15 miles south of the subject property. And then the applicants put in the map for unit B, which is 15 miles away, and there's a dashed line on it. No notation whatsoever on that dashed line. It doesn't say Oregon Trunk Railroad, it doesn't say railroad, it doesn't say anything. And so the only evidence they had in the record was there's a dashed line in unit B, and we think it's the railroad. Well, that I would argue is not substantial evidence that a reasonable person would rely upon to say that is this railroad that was built at some point in time that nobody can find now, and nobody could find in 1993, the relevant date. So we believe clearly the location of 7C was not dispositively addressed by LUBA. If it was, they wouldn't have put that footnote in that said the applicant hasn't relied upon it. I would say if the applicant wants to put 7C in, they have to apply and include 7C or request a modification. I don't think we can do a modification on the fly because, again, we have rights to participate. And if they're going to do a modification to their application, there's a process. And I cited it in my letter. There's a process that you have to go through to modify your application. That hasn't happened. So I think what we're really left with is what's in the current record on the location of 7C. What you have is a admission. They don't know where it is. We're not relying upon it. And you have nothing else, nothing to refute that. If you reopen the record, then they've got something in there that's not substantial evidence. But again, if you're going to reopen the record to allow that in, you have to give us a chance to respond to that, I think, because otherwise it would be significantly prejudicial to my client to have this new evidence come in without a response to it. So that's really our presentation. I think if you really, and I know you will do this, but if you really look at and break down what your findings were in reality, not how LUBA misstated them, and what LUBA really decided, what they decided as far as the location, I think you would agree LUBA never decided that 7B or 7C are in the template. It's a confusing decision. I think it could have been done better, but they didn't go as far as the applicant says. And so you have to look at whether or not there is substantial evidence in the current record that 7C is in the template. It's not there. There is no evidence that refutes that admission. And that admission, I think, is the only substantial evidence. It's overwhelming evidence that you cannot find that parcel. So if you have any questions, I'm going to be the only one presenting for our side. If you have questions, otherwise we want to hear from you on what you're going to do with the open record period and talk about that if you're inclined to reopen it, because I do want to talk about our rights to respond to that.
Okay, thank you. I think I have just one follow-up question, and it relates to some of your final comments, and I guess about it relates to Ms. Kellington having identified the portion of the county's remand code that says that the application can be modified as part of the remand proceeding. Do you have a response to that? It's section 2234.040, and it's subsection B of the code.
I don't have it in front of me, so I'm a little handicapped in responding to that.
Okay.
It came. You heard it when it came up. It wasn't in her letter. It wasn't in the PowerPoint. It just came up like 10 minutes ago.
Right, but it is part of the portion of the code that governs remand proceedings. So I think it's at least relevant for me to address that, and because it was an issue that was raised of whether or not this was a modification or not. I guess just so that I can, I think you'll have a chance to respond to it. I think that's I'll go ahead and preview a little bit of where I'm headed with the record, which is the way that this issue about 7C has come up and the dispute between the participants about whether or not it's in or out, I do think it is helpful to the hearings officer to have some discussion about that. And so for that reason, I'm inclined to let Ms. Kellington's letter that she submitted today into the record, but that does mean I would like to give you and your client a chance to respond to that. So I'm going to leave the record open for that purpose. And then, of course, if you want to, you can address that other code provision at the same time. But we'll have more discussion about that. If that concludes your presentation, then I'll just double check with Ms. House that there's no one else who has signed up to testify.
No, there's not anyone else.
Okay, so that we'll let Ms. Kellington come back up for a rebuttal, and then we can have a discussion. Since there's just two participants here, we'll have a little discussion about the procedure going forward.
Let me say something here. Oh, yeah, Mr. Brooks, my client, Randy Windlinx, does want to address you, if that's okay.
Yes, that's fine. I'll allow that.
Randy?
Randy Windlinx, 59895 Scale House Road, Bend, Oregon, 97702. Let's keep this in perspective. This Axis surveyor is the same surveyor that Liz Fancher and Tia Lewis relied on their application, and he could not determine where the railroad property was for his client at those times. So now we have an epiphany, and he now knows where it's at. I focus you guys on, especially the hearings officer, Mr. Brooks. You pull up that Ferguson deed that grants the right of way to the railroad. There is no specific meets and bounds location associated with that property with that deed. So I've been doing this. My professional training is engineering and surveying. There's no way that a surveyor can specifically locate that physical easement on that property. That easement actually crosses over onto my property. That railroad was never built. There's no evidence of that railroad ever existing. Either on paper, it was an intent to build it and never got built. The Great Northern Railroad got built in its place, and it was west of where that easement was located. And I just want to go on record to state that. So this idea that this surveyor is coming out of the woodwork at the last minute with this revelation that he knows now where it's at is absolutely a falsehood. And that's why they could not rely on it in their original two applications. So 7C is not even a consideration, more or less 7B, because they don't know where it's located through their own admission. Thank you very much.
Thank you. Ms. Kellington, would you like to offer your rebuttal?
Sure, thank you. It's really important to unpack what we just heard, because generalities are the enemy of the truth in the record. Number one, there can't be a modification here, can there? Because the hearings officer found that there were 9 candidate parcels, of which 7A, B, and C was included within the template. And LUBA recited that that was the issue that was framed that they were dealing with. There, if you look at the words on the page that the unrepresented at the time applicants wrote with regard to 7C, they said they believed that a part of 7C was in the template. Doesn't sound like an admission to me, but they said the exact location of the railroad wasn't known and they didn't want to deal with it. They didn't think they had to. But by the time Tia Lewis got a hold of the case, she took a look at the record, hired her surveyor, and made very clear in all of her submittals, to include her final written argument and her LUBA brief, that 7A, B, and C were very much in the hunt, that they were very much within the scope of the lawful parcels that the applicants were counting on. And so please don't allow really a misrepresentation of what the record says to color your view of the truth. The truth is Lot 7C has always been at issue, and LUBA decided it was at issue. And that can't be a modification of the application that comes up now, because if it was a modification that happened during the hearing process long before I was ever involved, long before LUBA was involved, long before you were involved. And it was something that was clarified and determined in the materials of Schwabe, Williamson, and Wyatt that were brought to you. And you found that those parcels, again, were in the template. You can try to pick apart the words that you wrote at page 17 and 13, but on both of those pages of your final opinion and order, it is clear that you made a determination that that Lot 7C was in the template. LUBA interpreted your final opinion and order to make a finding that Lot 7C was in the template, and therefore Lot 7C is in the template. If LUBA says it, if that's how they interpret your decision, that's the truth of the matter, unless LUBA is reversed on that topic, and we know that they were not. The other thing that is important to understand and sort of unpack in all of this is, why is it that the location of 7B was something that petitioners complained about below as well as at LUBA? I cite you to their brief at page 27 to 28 at LUBA. And they cite a case called Hall versus Meyer, which said that when you're trying to determine the difference between an easement and a fee conveyance, you look at two factors. One of them is the degree of precision with which the conveyance describes that part of the conveyor's land affected, and then the extent to which the conveyance limits the uses authorized. And so in their brief, petitioners said, well, the conveyance wasn't very specific, couldn't have been specific enough, and therefore the conveyance couldn't have been a fee, it had to be an easement. And while LUBA was not particularly kindly, maybe perhaps snarky about the depth of your findings on that topic, they specifically decided that those factors, including the legal description that was included in the conveyance from Ferguson to the railroad, was adequate to convey a fee, adequate to know where it is. And that's a final determination. Again, if petitioner didn't like it, their job was to appeal it. That's a final decision. And that, whether Lot 7B was determinable in its location is an issue that petitioners raised. They wanted to win it and they lost it. And when you lose an issue, just like we lost Lot 6, it's over. You don't get to bring it up again. And so Lot 7C is among the legal lots that you must decide. And this idea that there is no evidence in the record that Lot 7C is within the template is more than a little silly, because here it is. LUBA, in its final opinion and order, reproduced the survey. Can you see my image here of the template?
I can see it, yes.
Yeah, they reproduced in their final opinion order, page 16, the template. And it sure looks like a chunk of it heads over into Lot 7C. That's evidence, it's in the record. That template was prepared by a surveyor. What was it prepared on the basis of? It was prepared on the basis of the Ferguson patent. And so we've got the template. We've got the template that was provided by a surveyor. We've got your finding that is unchallenged and final, and that LUBA quoted, that says that, all of the lots are in the template. And now we have the surveyor's letter saying, yeah, Lot 7C is in the template, and it's not based on nothing. It's based on his survey. That's reflected on his template. It's based on the Ferguson deed, which he knows how to read, and the center line, which he was able to find. And that train has, left the building. The reality is the lot 7C being within the template is a decided issue. That lot 7B is adequately described so that you can figure out where it is a settled issue. And the only issue is lot 7C a legal lot? And Lovinger answers that question. So we're not supposed to be replaying issues that are settled. And the reason that I didn't have the surveyor make a big deal of 7C is I had no idea that someone was going to try to collaterally attack LUBA and the Court of Appeals decision on that. That seemed to me to be a settled issue. And it wasn't until around 2 or so this afternoon when I got the missive from Mr. Kobach that decided to challenge 7C and try to reopen this issue. So apologies for being a little late to the party on that issue, but I don't think we can be faulted for that because the issue is supposed to be settled. If I don't think that you're not going to get into, I don't think all of this. I think you're going to be able to come up to a very high level and decide that the issue is pretty simple. Was 7C created by deed? Yes, it was. It was created by the railroad deed under Lovinger. That's kind of the end of the story. But there is a lot of evidence in the record that the county relied upon when it approved the template dwelling several years ago that expired due to personal circumstances. So it's not like there's this sort of renegade rogue record out there. There's a pretty well-developed record that if you want to get into it, and you want to trace all this stuff, you certainly can. And there's plenty of it to support a conclusion that, again, 7B was adequately described enough to tell where 7C is. If you want to get into the 2234040 issue, I would do it in the alternative, because I think you have plenty to rely upon in LUBA's decision and your unchallenged and final findings with regard to the lots that were in the template. But it probably wouldn't hurt to, in the alternative, say that to the extent that 7C was not clearly a part of the case before, notwithstanding that you made findings it was, and that LUBA remanded on the basis of it, that you have the discretion to make clear it's added now and that you should add it under 2234040, but in the alternative only. So for all of those reasons, I can't imagine that there are not 7 lawful parcels, and that the template shouldn't be reapproved. And if you have any questions, let me know. Otherwise, I would like to participate in this open record discussion. Yeah, that's what I know.
Right. Thank you, Ms. Kellington. Since you're up, I'll just ask you, go ahead and ask you about this open record. So here's my thinking on it, is that an argument was presented by Mr. Kobach that the lot 7C was a live issue. You have submitted, and I haven't read it yet, so I don't know, I can't characterize it exactly, but it sounds like new evidence that addresses that issue. But because it's new evidence, I feel compelled to leave the record open solely for a response to that. So that, I guess the choice would be really yours if you want the surveyor's letter that you submitted to remain in the record and for me to consider that as part of my decision. I would like to leave the record open for Mr. Kobach to respond to that. Alternatively, you could say that you're not going to include it in the record, in which case I would keep the record closed. So do you have thoughts on either of those approaches?
Yeah, it's a little bit, if you're a Star Trek fan, like the Kobayashi Maru in Star Trek 4, it's a little bit of a no-win situation for me to answer that question. I think that I would like to leave it in the record, but here's what I foresee happening. So I had our surveyor write a letter that was kind of what we would say quick and dirty to respond to the surprising letter that I received this afternoon from Mr. Kobach to kind of put to bed this 7C issue. But it sounds like you're feeling like it's an issue that you want to really roll up your sleeves and get into. And so I think based on that, what I'd like to do is to have the surveyor in painful detail, in a very detailed declaration, explain his exact process for deciding that it's in the template, so that, there is no stone unturned, and we don't end up with me getting, some detailed thing from Mr. Kobach saying, well, that can't be good enough because of this, and this. And we're just going back and forth, back and forth. So where I come down on that is that I feel like the record should be reopened to allow that evidence. But given how things have turned, I think that the record should be open to both parties for a period of 7 days to submit further evidence and argument on the 7C issue.
Okay, thank you. I think that's a reasonable approach. I will just, I'm not going to entertain, sir rebuttal and continuous on. But if your request is to keep the record open for both parties for 7 days, I'm inclined to do that just on this very narrow issue about whether or not, on the 7C, lot 7C, and then give both parties an opportunity to respond to that. Mr. Kobach, I see you've rolled up to the table. So is there anything you'd like me to consider about that request?
No, I rolled up here because I expected that you'd be asking me for my position on this. And I'm trying to kind of understand exactly where we're at. So the request today was to reopen the record to allow this one letter in. And we opposed it unless we got an opportunity to respond to it. And now there's a different request. I understand that the applicant's going to put something more in.
I think that's an accurate summary. The request on the table is to keep the record open for a period of 7 days for both parties to address this issue that's already been, I guess, raised by you and responded to by Ms. Kellington or through the surveyor's letter. Again, I think because the issue was raised in argument, I do find it would be useful to have evidence from the parties, especially because it seems to be a point of contention. And so the approach would be to leave it open for both parties for 7 days, with both parties having an opportunity to respond to that.
Okay. That seems like a reasonable approach. But since we have very few days burned on the 120 day, could the first period be 2 weeks? Just from scheduling, I've got some other things I have to attend to.
I can consider that. I'd like to hear from Ms. Kellington too, if we could do 14/7 instead of 7/7. I don't know if you have a response to that.
I don't want to make anybody's life difficult. I mean, that's not what I aspire to. I think so I'm not sure exactly where you're going with this, but to me, this doesn't take an awful lot of time. This is a technical thing for a surveyor to write a declaration about. And I suppose I can foresee that parties are going to say, maybe even we'd say, oh, we need to respond to whatever somebody puts in. So the net result could be 14 days if there's an initial 7 and then a subsequent 7. I think that would make sense, like okay, here's a response. And I think you said that's what you wanted to do. That's what you were thinking made sense. Is that, or did I just miss it?
So I haven't expressed an opinion yet. I'm just trying to characterize the requests and
So
see if you guys.
I think
so I don't have
7 days for the initial and a 7-day to respond. So that's a period of 14 days. I think that's fine, assuming you guys are okay on the 120. I don't know where you are.
Right. So I think what Mr. Kovac was suggesting was that it'd be a 14-day period initially, followed by a 7-day period.
Yeah,
That's correct.
I don't like that. I don't like that. I feel like it's just rife for mischief. This is an issue that they raised at the last minute. We provided a very detailed remand request that laid everything out. I did it well in advance so that, you know, everything was on the table, what we were thinking. And, you know, these guys at the last minute, 3 hours before the hearing, roll in with this brand new issue, trying to, gin up an issue that's been resolved for a long time. And I don't think it's fair or right to, extend it by 2 weeks. I think a week is plenty.
Okay.
All of us are busy.
Well, that characterization of last minute is a little disingenuous. If you read the remand letter on the issues resolved, they never said, oh, and 7C is in the template.
So
They didn't present that as an issue that had already been resolved. I'm reading it right here.
Mr.
And
Kovac,
furthermore, to say that we just
sorry to
snuck-
interrupt you, but so I feel like we're getting a little far from the actual decision that's in front of me now about the record. So I think I can understand how this is raised. I think I have from both of you what I need in order to make a decision about the record. So before we turn to staff and do that, is there any other procedural issues for either of you that I need to be aware of?
Thank you.
Is the application modified? That's a big question. Is 7C part of the application? Because it seems like you're saying we're going to address this with new evidence. It's implicit in that almost is that 7C is part of this application, or are we still going to brief whether a modification is required?
I don't think I need briefing on that. I think that's a legal issue. I think you guys have both presented your position on that. So I don't think that's part of what we're talking about.
Okay. And then the last thing is just the reality of it is in Central Oregon, the surveyors are hard to get to, they're busy. So I don't think 2 weeks is an unreasonable period of time for us to go out, because now we have for the first time we have a surveyor saying he's attesting to something. I got to get a surveyor.
Okay. Thank you both. I'm going to turn to staff now, not about the procedural stuff. Staff is just if there's any other comments you feel compelled to make.
No, I don't have any closing comments.
Okay,
Subject.
thank you. So here's how I'd like to proceed. I think just given the posture of this issue, the remand application was submitted quite a while ago. And Mr. Kovac, because you initially sort of raised this issue that I think is initiated the response, I'm just going to keep the record open for 7 days for both parties. It's an issue I feel like the appellant has already given some thought to. So the extra week, especially if the applicant's not going to agree to it, I'm going to just keep it at 7 and 7, which is also pretty standard for any open record period. And we'll keep it at that. So the 7 days from today, and staff will go over this. Hopefully it will help me at the end to make sure I calculate the dates right. But we'll leave the record open for this limited purpose for 7 days for both parties to address this issue of whether or not 7C is it was in the template, and then a period of 7 days for the participants to respond to that. And at that point, the record will be closed. If I could turn to you, Ms. House, to help me figure out if I've calculated the dates right. I accidentally just closed my calendar.
Yeah, let me just share my screen real quickly. So based on what I just heard, so new evidence and testimony can be submitted through Wednesday, September 6th, the 4 p.m. deadline. And then both parties can provide rebuttal testimony and final legal arguments through, I guess, Wednesday, September 13th at 4 p.m. And I'll just note while I'm doing my screen share, all submittals should be sent to me, Caroline House. My email's on the screen. It's Caroline House, caroline.house@deschutes.org. And we don't retrieve any information from like a cloud storage program or a website link. So make sure you include the actual material that you're providing and make sure everything's actually received by 4 p.m. to the last minute. We've had issues with stuff not coming through.
Can I ask a point of clarification? When you say September 6th for new evidence, any new evidence, right?
I'm going to defer to hearings.
Yeah, Mr. Brooks, is that the ruling? It's new evidence
On that issue, not
on that issue, right? And then rebuttal is new rebuttal evidence on that issue.
correct.
Okay, thank you.
And just that this is the only issue that the record is continuing to be held open for.
Okay.
And hearings officer Brooks, I just want to note too that there is no extension of 120-day clock. I don't know if that matters in your decision or not, but whether the applicant agrees or not, whatever time that is going towards this post-hearing open record period will count towards the 120-day clock.
Okay, thank you for pointing that out. I will review that in my decision and clarify that and note for the parties what the 150-day clock is, or what the clock is, the remand clock. All right, thank you for your patience, and working together to try to figure out the record period. We will go off the record at 7:22 p.m.
Thank you.
Thanks.